My name is Toby Craddock and I'm one of the barristers here at Dean's Court Chambers. I specialise in family law. Today I want to welcome you back to the Dean's Court Chambers online seminar series, and I'm going to be talking to you today about the law of surrogacy. An introduction to the law of surrogacy, because it is such a fast-paced area of the law, trying to respond quickly to the new ways in which we as a society are recognising different types of families, and also trying to keep up with the developments in medicine and fertility treatments. I'm going to talk to you today about the main statutory provisions in relation to the law of surrogacy, and also how many applicants, prospective parents who want to seek parental orders, the problems that they can encounter and how the court has responded to those. The surrogacy landscape, as I've already said, is an ever-evolving one, and because of that, it challenges some of the long-established principles of law in the United Kingdom, which is obviously very different to other countries and how they choose to regulate surrogacy arrangements. Because we have lots of people who want to start a family and use surrogates from overseas, there can sometimes be some confusion as to what the surrogate mother's rights are compared to the parents' rights when we look at those arrangements and how they apply to the law of England and Wales. And this is what Mrs. Justice Theus, who is a very prominent High Court judge who regularly deals with issues in relation to surrogacy, has summarised the problem. She's very clear. Prospective applicants really must regulate these arrangements after the child is born to avoid complications further down the line. The reason why these arrangements ought to be regulated is because under the United Kingdom's version of surrogacy law, the woman who gives birth, the surrogate, is deemed to be that child's legal parent, even though she may not have any biological or genetic link to the child because a donor egg has been implanted. So it's very important that we address the default position where we have couples or single parents who want to start a family with the assistance of a surrogate and be recognised in law as this child's biological and social parent. There are many reasons for that, and the court will address those in the case law that I'm going to take you through. But clearly, one can appreciate that it's very important for the child themselves to understand their own identity. The starting point is Section 54 of the Human Fertilisation and Embryology Act 2008. A very lengthy piece of legislation and a very long name, so from now on I'm going to be referring to it as the HFEA. You'll be able to see on this slide, although it may be slightly obstructed by the webcam, that there are a number of conditions which have to be satisfied before the court will make a parental order in favour of the child's parents, which therefore recognises them in law as the child's parents and extinguishes all legal ties between the surrogate and her partner, if she has one, and the child themselves. It is commonly referred to as a checklist because there are a number of conditions which have to be satisfied before the court will make such an order. Clearly, for people who have gone into a surrogacy arrangement with a friend, this could pose some problems because the conditions which have to be satisfied are quite lengthy. But I'm going to take you through them now. And I should state that all of these slides will be available on the Dean's Court Chambers website, so you can read them in full at a later date should you so wish. So, first off, conception must have taken place by embryo transfer or artificial insemination and the child must have been carried by a surrogate. That is what you would expect. And the intended parents must be, at least one of them, the child's biological parents. So far, so good, not controversial. But from subsection 2 onwards, these are the conditions that have to be met. So there are applicants that must be husband and wife or civil partners of each other, or two persons who are living as partners in an enduring family relationship. Now, what about a single parent? Well, we're going to come on to that shortly. Secondly, they must apply for a parental order within 6 months from the date of which the child is born. Now, I'm sure many practitioners can imagine the situation with a client attending their office and asking whether or not they should apply for a parental order in respect of their darling new baby who has just turned 6 months last week. What can the court do in those circumstances? Again, that's something that we're going to consider in due course. The rest of the conditions are as follows. At the date that they apply for the order and the date the order is made, the child must have his or her home with the intended parents. And at the date they apply and the date the order is made, the intended parents must be domiciled in a part of the United Kingdom, the Channel Islands, or the Isle of Man. At the time of the making of the order, both applicants have to be 18, and the surrogate and her spouse, if she has one, must fully and freely consent to the order unless they cannot be found or they are incapable of giving consent. Notably, subsection 7 places a caveat on that, in that the surrogate mother's valid consent cannot be obtained until after 6 weeks after the birth. For obvious reasons, she has to recover from the birth and she has to be in a position where she's in the right frame of mind to make such an important decision. Lastly, no more than reasonable expenses can be paid. And if there are any payments, the court has to authorise them in retrospect. Contrary to some of the other jurisdictions, I'm thinking of California, and I hate to use this term, but the courts of England and Wales are very clear that you cannot buy a baby. There cannot be a surrogacy contract as such. Now, I referred to a moment ago the situation as it affects legal parents, because section 54 subsection 2 in its current wording applies to spouses and civil partnerships or those in an enduring relationship. However, the law has moved on. We have two cases, both before the former president of the family division, the Mr. Justice Mumby, and it was in Reezy Child number 2, the second of those cases, where the court found that to discriminate against a single parent in the way that the section of the HFEA does would be incompatible with both the single parent's rights to a family life, which are protected by Article 8, and also there is a prohibition on any form of discrimination by Article 14 of the Convention on Human Rights. The facts of that case are as follows. It was a single parent, a father, who had travelled to Minnesota in America, and he had obtained a donor egg, and he implanted that with his sperm with a fertility clinic in Minnesota into a surrogate. So the surrogate mother had no genetic link to the child, and the donor egg was not from the surrogate, nor was the donor playing a part in the child's life. So we have a situation in Minnesota where the applicant entered into a surrogacy agreement which extinguished the surrogate's rights upon the child's birth, which, as we all know, would be enforceable under Minnesota law, but in England and Wales we don't recognise such agreements because they're not governed by our laws. The consequence of that is that when the father touched down in England at the airport with his newborn baby, um, the laws in England, as I've previously stated, would say that the gestational mother, the surrogate, is this child's mother. She's not here. She can't exercise her rights under English law for the child. And the father has no rights because he is not her spouse and he does not have parental responsibility. So, who is exercising parental responsibility for this child in the eyes of the English law? No one. So, the High Court makes a child a ward of the court, and then the applicant, single father, makes his application for parental responsibility order because, as he argues with leading counsel, that the sections of the HFEA are incompatible with his convention rights. President Mumby, as he then was, as I've said, declared that that would be incompatible with his convention rights, and the law was changed. And for all of the lawyers, you know what this means. There has to be some more reading because now we have Section 54A of the Human Fertilisation and Embryology Act, which protects the rights of single parents and promotes a way forward for them to have a parental order recognised in their name alone. And the conditions are very similar and it's underpinned by a separate set of regulations, but that may need to be the subject for a further seminar. I also referred to what happens when you have the situation where you're trying to apply for a parental order out of time, so after the child is 6 months old. Again, President Mumby, as he then was, in the case of REX, a child surrogacy time limit, considered whether or not it was the intention of Parliament when it enacted the Human Fertilisation and Embryology Act to bar someone in case the child was 6 months and a day old. Having considered the linguistic structure of the section and also the fact that we have to take into account the importance of the parental order, not just on the applicant, but on the child throughout their life as it relates to their identity and with, as ever, the child's welfare being the paramount consideration of the court, President Mumby determined that the provision at section 54(3) is not absolute and the time limit can be extended in appropriate circumstances, and again that will be determined on a case-by-case basis in relation to the factors that I've just mentioned. Finally, something that concerns all prospective parents when they enter into any form of surrogacy arrangement: what happens if my surrogate changes their mind? Well, that's what happened, sadly, in Re-AB Surrogacy Consent 2016, and this was decided by Mrs. Justice Theus. In short, the surrogate mother and her partner had no biological connection to the child she was carrying, and they entered into a surrogacy arrangement with the applicants who were the biological parents. They fell out. I don't know why, but suffice to say, the surrogate and her partner withdrew their consent to the making of a parental order. Very sadly, the court was absolutely satisfied that a parental order was the right order for these children versus a child arrangements order versus an adoption order and versus a special guardianship order. And I've quoted this in particular because it says an adopted child is seen to have had a family created for it, whereas in a surrogacy arrangement, the child's conception and birth has been commissioned by the parents. The child has a biological connection and the same identity as one of the parents. The latter arrangement is more congruent with a parental order than an adoption order. So, consent. At the moment, it is absolutely essential from the surrogates if there is going to be a parental order made. In California, it can be contracted out prior to birth. Are we on our way to California-style surrogacy? I know not. Academics say that it could create a subclass of children, with surrogate children seen to be as entitled to a more privileged legal protection. Now, the slides are available on the website, and I hope you've enjoyed watching.